Everybody. Welcome back to another live stream with a Ford Law. Just wanted to touch base with you, and my topic for today is the right to remain silent, your Miranda rights. It's very important that you understand what these rights are, when they apply, and what protections you have as a result of Miranda. So let me just back up and give you a little bit of background about Miranda. Miranda is called that because it came from a case. It called a case involving Arizona versus Miranda. In that case, the Supreme Court of the United States at that point decided that every criminal client has the right to an attorney. And if that person cannot afford an attorney will be provided for them. So as you all know from watching TV and movies and so forth, the Miranda warning is basically you have the right to remain silent. Anything you say can and will be used against you in a court of law. If you cannot afford, and you have the right to an attorney. If you cannot afford an attorney, one will be provided for you. And basically, you don't have to answer any questions by the police. Those are extremely important constitutional rights. And you should keep them in mind if you're ever encountering the police on the outside. When do Miranda warnings have to be given? The police have to give you Miranda warnings when you are in custodial, when there is a custodial interrogation. So that's a two-step process. First, you have to be in custody, and secondly, there has to be an interrogation by the police or somebody acting on behalf of the police department. So clearly, and when you're arrested, you're in custody. That's an easy one. But there are many other cases where you are considered in custody, and your Miranda rights may have to kick in. So custody basically is any encounter a citizen has, an individual has, with the police, whereby a reasonable person, so that is an objective standard, a reasonable person would believe that the individual, that's you, does not have the right to leave. They're being held there by the police for some period of time. Even a very small amount of time would qualify for being in custody. So for instance, we often see cases where if somebody is, well, certainly if you're pulled over by the police, if you're driving, you get pulled over, that's considered custody because you can't leave, and a reasonable person would know you can't just drive off without talking to the police. Custody also involves if you're somewhere. This is a very important factual situation where if you've parked your car, you're in your car, and the police come up behind you and block you in, and so that you can't get out, you are considered in custody for Miranda purposes at that point. If officers are surrounding your car and you don't feel like you can get out and leave, that could be a custody situation as well. It's very important to decide when custody happens, because, as I say, that's the threshold to your Miranda rights kicking in and being afforded those protections. So what happens is a lot of times people say, well, I was arrested, but the police never read me my rights. I want to get my case. I think my case should be dismissed. That's not how Miranda works. Even if the police don't read you your rights when they arrest you or back at the police station during booking, which they probably will, and they'll probably have you sign a form that you have been read your Miranda rights and you understand them. They don't have to give you those rights. It does, however, come up in the situation where the police have you in custody and you make some sort of incriminating statement. So you make some sort of statement against your interest that would subject you to criminal liability. If that happens and you have not been advised of your Miranda rights, your attorney, us if you hire us, would make a motion to suppress those statements. That is, to not allow them to come into testimony. That's a huge win for a defense if they can knock out any sort of statement that you've made that would that would help the prosecution find you guilty of the charges. So the first step is that you must be in custody. The second step is there must be an interrogation. So there's a custodial interrogation. The interrogation is when, again, clearly you know what it is. If you're in the police, you're in an interrogation room, the police are asking you questions for hours. Clearly that's an interrogation. But that's not the only way that police can interrogate you. You have to be, again, have to be in custody somehow, and they're asking questions of you to get some sort of information. So, for instance, if they're asking you direct questions, that's an interrogation. There's also cases where the police will be talking to one another. So one officer will be talking to another officer, knowing that you can hear them, and they would be making statements to each other, trying to get you to say something in response to that. So, for instance, if the two officers are talking and they say something like, let's just say that you've been arrested and taken into the station, you and a friend, and the police have you in custody. They're having a conversation between the two of them, and one of them says, "Hey, did you hear that the friend, the other guy, just said that you are the one that's committed the crime, that was the main actor, it was all your idea," that sort of thing. They didn't ask you any questions, not even talking to you, but they know that you can hear them, and they're trying to elicit an incriminating response. That can be considered interrogation as well. You need to have been given your rights, your Miranda rights, before that happens, in order for any statement that you make to come into evidence at time of trial. So it's a crucially important rule that we have, crucially important protections that you have under Miranda. So you should understand what those Miranda warnings are, when they apply, and what can happen as a result of it. The number one piece of advice that I can give any criminal defendant or anybody that's going to encounter the police in any way is, do not talk to the police. Don't make any statements to the police whatsoever. You can give them if you get stopped, you need to produce, if you're driving and you get stopped, you need to produce your license, registration, proof of insurance, but you don't need to speak to the police. If you get pulled over, let's say, as an example, they suspect that you're driving under the influence, so you're drunk driving. They're going to be asking you lots and lots of questions. They're going to ask you, where are you coming from? Where are you going to? Did you have anything to drink? Did you have anything to eat? When was the last time you had anything? They're going to try to engage you in conversation. And this is going to be a fairly casual sounding conversation to you. It's not like they're coming in, really hardcore and trying to get that information out of you. They're trying to be conversational so that you're kind of put off guard, kind of relaxed, and you're going to make statements. Any statements that you make can and will be used against you in a court of law. A lot of times people think that they can talk to the police, they'll get out of the trouble or whatever it is by making these statements, giving them some information. That is not true. Don't believe it. You're not going to be able to talk your way out of a criminal charge at that point. Anything that you say can and will be used against you. Even if it seems like it's a nothing statement to you, there's no importance, you're not admitting to anything, the police can turn that around and use that against you. As an example, sometimes people will say, I was at a particular scene where a crime occurred, but I had nothing to do with the crime whatsoever. It sounds like you're getting yourself out of trouble, right? With a statement like that, and that's your intent. But what you've just done is you've placed yourself at the scene of the crime. They may not have any other evidence that you were even there, but now they know that you were at that scene. So that's one step closer for the prosecution making a case against you on this. And you thought you were just making a casual statement, even a statement that would get you out of trouble. It's way, way too important. And it's just, if you haven't seen this a lot of times, you don't, someone may not understand exactly the full extent of the trouble that you can get into, to be quite frank. Don't give statements to the police. Be polite with the police. If you encounter them, you don't have to answer that question. So if they say, have you had anything to drink tonight? Where are you coming from? Where are you going to? Tell them, I don't make any statements. I don't make any statements, or no comment, or something along those lines. Keep it as short as possible, not to give them any reason. And you say, am I free to leave? Am I free to leave? If you get stopped for something, let's say it's a motor vehicle violation, you have a tail light out or something like that, that encounter with the police can only last as long as it takes to deal with that situation. So if it's a tail light, your car is registered, your license is valid, your insurance is up to date, they can give you a ticket and send you on your way. They will try to look into things to see if there's anything else that's going on, any other criminal activity that they can charge you with. Don't give them any opportunities to do so. Keep the stop as quick as possible with no statements whatsoever and be on your way. So that's our tip for today. It's a criminal law tip. We at Afford Law charge our clients on a sliding scale fee. We make ourselves affordable to as many people as possible. Our sliding scale is set up so that the less you earn, the less income you have, the less we charge as far as our fee goes. It's way too important in criminal and family law matters for you not to be represented by somebody. I know that lawyers can be expensive, and most of the time they are. We are here specifically to try to provide experienced legal representation in family law and criminal law cases at a reduced rate. So if you have any questions, please feel free to visit us at affordlaw.org. That's O-R-G, not .com, affordlaw.org. See if you qualify for our reduced rates. Give us a call. We'd be happy to set up a telephone consultation with you for free. So give us a call anytime. Visit us. Email us. I'm at paul@affordlaw.org. Thank you very much for listening, and we'll talk to you down the road.